Welcome back to the Constitutional Clarion. My apologies for the delay in uploading a video on the Commonwealth's Combatting Antisemitism, Hate and Extremism Bill. I'm afraid the bill is so long and complex that I've spent the last couple of days trying to get to grips with it, while also writing a submission to a parliamentary inquiry and doing many media interviews and opinion pieces about it, which meant that I just didn't have time to do a Clarion, but I'm here now. While at the time of making this video, the fate of the bill remains unknown, and my analysis may therefore become completely redundant, I'm going to focus in this video on the proposed offence of promoting and inciting racial hatred. I'll do a separate video about the provisions for banning hate groups. There are also a lot of other aspects of the bill which so far I just haven't had a chance to analyse, so I might do something on that later depending upon how things play out in Parliament. Regular viewers will have seen that I did do a previous video about the Keating government's attempt to enact a law criminalising hate speech and why it failed. I recommend you watch that to understand the history and the context of what's been happening now. I've also done videos on the New South Wales provisions concerning hate speech, which might be of some assistance. This new Commonwealth proposed law is a little bit different because it wants also to catch speech that does not go as far as inciting racial hatred. It therefore proposes to make it an offence to promote racial hatred. Proposed section 80.2bf says that a person commits an offence if they engage in conduct in public, and that includes online, intending to promote or incite hatred of another person or group because of their race, colour or national or ethnic origin. It also makes it an offence to disseminate ideas of superiority over or hatred of people because of their race, colour or national or ethnic origin. In both cases, it's only an offence if the conduct would cause a reasonable person who belonged to that targeted group to be intimidated, fear harassment or violence, or fear for their safety. Pauline Hanson has claimed that this would mean that saying that Australia is the best country in the world would make someone a criminal, subject to 5 years imprisonment. Now, I don't think so. I've got my problems with this provision and I am going to criticise it shortly for those of you who turn off early, but the problem is not the one identified by Hanson. The bit about disseminating ideas of superiority or hatred of people because of their race is really aimed at picking up claims of racial superiority like Nazi claims about Aryan people being superior to other races. It might, however, have come into play in the past when politicians in Australia supported the White Australia policy on the basis of a claim of superiority over other races or different coloured peoples. Saying that Australia is the best country doesn't amount to an assertion of superiority over or hatred of another person or group because of their race, colour or national or ethnic origin. Australians, of course, are members of many different races and ethnic origins, so praising Australians and Australia doesn't suggest racial superiority. In addition, for it to be an offence, it would have to cause a reasonable person who is a member of the targeted group to be intimidated, to fear harassments or violence or for their safety. So, which person or group would be targeted by a statement that Australia is the best country in the world? A group of every other nationality in the world? And how would a reasonable person from that group feel intimidated, fear harassment or violence or fear for their safety as a consequence? Personally, I'm more concerned about the broad scope of the offence of promoting racial hatred. According to paragraph 245 of the explanatory memorandum, promote is intended to refer to conduct which encourages, advocates, or endorses hatred, even if it does not directly urge others to act. Promotion, it said, would include normalising or legitimising hateful attitudes in public discourse. Now, there's an awful lot of material that historically has normalised hateful attitudes, including Shakespeare's The Merchant of Venice in its treatment of the Jewish moneylender Shylock. Would a performance of that play today normalise hateful attitudes? And would it cause a reasonable member of the targeted community to fear for their safety? Ordinarily, one would assume that it wouldn't. But I read an article in the newspaper recently about a performance of The Merchant of Venice being suspended or deferred in Sydney precisely because of fears in the Jewish community that it might inflame anti-Semitism and put them at risk. So yes, this actually is a real issue, even in relation to works that are centuries old from part of our literary canon. But let's start with the question of what power does the Commonwealth have to enact this law? The Commonwealth Parliament, of course, can only make laws about subjects over which the Constitution gives it power. There's no express right to make laws about human rights for the Commonwealth. So the Commonwealth instead relies on the external affairs power in section 51(29) of the Constitution on the ground that it's implementing Australia's treaty obligations. Now, one of them comes from Article 22 of the International Covenant on Civil and Political Rights, known as the ICCPR. It says, any advocacy of national, racial or religious hatred that constitutes incitement to discrimination, hostility or violence shall be prohibited by law. Now, that shows that it ties the advocacy of racial hatred to an outcome of inciting discrimination, hostility or violence. It doesn't support the lesser standard of simply promoting hatred, which does not incite any action. While that might seem like a fine distinction, one must remember that the ICCPR also protects the fundamental right of freedom of expression, and this racial hatred exception is very specifically set to this level and not a lower level in order to minimise the restriction of freedom of expression. Second, there is Article 4A of the Convention on the Elimination of All Forms of Racial Discrimination. It says that countries shall declare an offence, punishable by law, all dissemination of ideas based on racial superiority or hatred. So that's where that bit from the section I just referred to comes from, as well as incitement to racial discrimination, as well as all acts of violence or incitement to such acts against any race or group of persons of another colour or ethnic origin, and also the provision of any assistance to racist activities, including the financing thereof. Now, again, it's incitement of discrimination or violence, which is targeted by the provision. Article 4 is also subject to the caveat that parties must act with due regard to the principles embodied in the Universal Declaration of Human Rights, which of course includes freedom of speech, and the rights expressly set forth in Article 5 of this convention, which includes the enjoyment of the right to freedom of opinion and expression. Because the word promotion sets a much lower standard than either of the treaty obligations that the Commonwealth relies on, this makes its validity questionable. Sometimes the High Court has been very strict about implementing only the specific wording of a treaty obligation and not going beyond it. So an example is Victoria and the Commonwealth from 1996. But on other occasions, it has not been so strict. It's enough to say that doubts may be raised about the validity of the offence of promoting racial hatred. One possibility is that if it were challenged, the High Court might sever, that is, cut out, the words promote or from proposed section 80.2bf and leave the rest of it standing, if of course the rest fell within the scope of the treaty obligations. The second constitutional question is whether the law would breach the constitutionally implied freedom of political communication. Not all statements promoting or inciting racial hatred would be regarded as political communications, but many potentially could fall within that category. Criminalising the making of such political communications would burden the implied freedom, and the law will be invalid unless it's for a legitimate purpose, that is compatible with the constitutionally prescribed system of representative and responsible government, and the law is reasonably appropriate and adapted to advance that legitimate end. This is likely to come down to an argument about whether the law is sufficiently narrowly tailored to achieve the legitimate end of protecting people from harm without disproportionately burdening freedom of political communication. On its face, the provision could catch conduct which completely accurately describes crimes or atrocities committed by persons of a particular race or national or ethnic origin. The person who makes the communication, who wishes the world to know of the horrors that have been perpetrated and presumably genuinely feels anger towards those who did it, might be said to intend to promote hatred of that group, as this is the likely consequence of publicising what happened. And a reasonable person of that group might also feel intimidated or fear harassment or violence for their safety as a consequence. According to the explanatory memorandum and section 5.2 of the Criminal Code, the fault element requires that the person meant to promote or incite hatred or is aware that this will occur in the ordinary course of events. So even if a person does not personally want to cause hatred, but he or she communicates the truth about horrific events, knowing that the consequence in the ordinary course will be the spread of hatred against the racial or ethnic group whose members perpetrated the act, this is enough for the person to be convicted, as long as a reasonable person from that group would feel intimidated or be fearful. Now, you may think that there has to be a defence of truth, surely, but there isn't. There are a range of defences that already exist in section 80.3 of the Criminal Code, but most of them seem to be ill-fitting for the offence of promoting or inciting racial hatred. They include acting in good faith to show that the sovereign, Governor-General, governor or a head of government in another country is mistaken in their policies or actions, point out errors or defects in the Constitution, legislation, an Australian government or in the administration of justice with a view to reforming them, urge others to attempt lawful change to a law, policy or governmental practice or in Australia, or do anything in connection with an industrial dispute or matter. There are also two defences that may be relevant to racial hatred offences. One is a defence of pointing out in good faith any matters causing ill will or hostility between different groups in order to bring about the removal of those matters. But it's rather hard to see how it applies to this example. Telling people about a crime or atrocity that has occurred is not really pointing out matters that are causing ill will in order to bring about their removal. It's actually causing the ill will by attributing blame for actions, and doing so doesn't actually bring about the removal of the cause. The crime or atrocity has already happened and can't be reversed. The more relevant defence is if a person publishes in good faith a report or commentary about a matter of public interest. Now that would potentially cover news reporting of events, but it's not an absolute defence. Section 80.3.3 says that in considering such a defence, the court may have regard to matters including whether the act was done in the development, performance, exhibition or distribution of an artistic work, or for any genuine academic, artistic or scientific purpose, or any other genuine purpose in the public interest, or in the dissemination of news or current affairs. But these are just factors to be considered in assessing the defences that I've already outlined above, which are under section 80.3.1. There's no separate defence for artistic works or communications made for any genuine academic, artistic or scientific purpose. One would therefore have to shoehorn communications of that nature into the defences in 80.3.1. It would be hard, for example, to establish that a painting, such as Picasso's Guernica, was a publication in good faith of a report or commentary about a matter of public interest, or that it was pointing out in good faith matters producing feelings of ill will or hostility between different groups to bring about the removal of those matters. The media would be partially protected by these defences, at least to the extent that it was disseminating news or current affairs and it amounted to a report or commentary about a matter of public interest. But it does have to be reported in good faith. If media commentators were whipping up fear of ethnic crime gangs and hatred of the ethnic community they belong to, then they could potentially be prosecuted. Politicians would also be exposed, except for statements made in Parliament and protected by parliamentary privilege. People who engage in social media commentary would be particularly vulnerable, as has been seen in the United Kingdom. And this includes comments in the comment sections to my videos, which I do occasionally close on sensitive topics like this one, due to the many comments made which already potentially breach a range of existing laws, not to mention this proposed one. Section 80.32 also says that in considering a defence, the court may have regard to whether the acts were done with the intention of causing violence or creating a public disorder or disturbance. The bill adds to that list of negative considerations whether the act was done with the intention of promoting or inciting racial hatred or disseminating ideas of superiority over or hatred of another group because of their race, colour or national or ethnic origin. Now, this is quite peculiar because it's a key element of the offence for which the accused is claiming the defence. So if we have an offence of promoting or inciting racial hatred and then a defence of publishing in good faith a report or commentary about a matter of public interest, and then the court is told that in considering that defence, it may have regard to a number of negative factors, including that the acts were done with the intention of promoting or inciting racial hatred, we have a very weird circular argument going on, and how a court would interpret that is anyone's guess, but it could potentially render all the defences ineffective. It would be preferable for proper consideration to be given to what defences are appropriate in relation to proposed section 80.2bf rather than dealing with these existing ill-fitting ones. In considering whether proposed section 80.2bf breaches the implied freedom of political communication, a court would consider what defences existed to limit the scope of the burden on the implied freedom. In the case of Faruqi and Hansen, about which I've also done a previous video, from 2024, and I note that this case is currently on appeal, Justice Stewart, in upholding the validity of Section 18C of the Racial Discrimination Act, concluded that the burden on the implied freedom was slight because the defences in Section 18D were so broad that there was little political communication that was affected. Defences are therefore important to constitutional validity and need to be given better scrutiny. Overall, I'm concerned about this provision. On the one hand, it will probably rarely, if ever, be used because it will be hard to prove such matters to the criminal standard of beyond reasonable doubt. But on the other hand, it is likely to have the effect of shutting down discussion about any political matters that concern race or people of particular racial or ethnic groups due to fear of prosecution and the very severe penalty of 5 years imprisonment. We already have Section 18C of the Racial Discrimination Act, which makes it a civil offence to offend, insult, humiliate or intimidate a person or group on the grounds of race, colour or national or ethnic origin. It also has a much more appropriate set of exemptions. People can bring complaints themselves about breaches of it, so they don't have to rely on police or prosecutors to act. And the Australian Human Rights Commission conciliates complaints to reach an agreed outcome and a better understanding of the racial issues involved. If conciliation fails, the matter can go to a court which can order compensation or make other orders. No one, at least as far as I've heard, has yet properly explained why criminal sanctions are needed instead, and how they would improve social cohesion or prevent racial hatred. It seems to be a case of the government must do something strong now. This is something strong, therefore the government must do it now. In my view, it would be much better to take some time to consider properly what will actually help more than it harms, especially in the long term, rather than just doing something now for the sake of being seen to do it. Thank you for watching The Constitutional Clarion, and as always, I look forward to seeing you again next time. Goodbye.